Good day from me, Adv Nadene Badenhorst, the Legal Counsel of Freedom of Religion South Africa, or 4SA. This is the third video in our series on the PEPUDA Amendment Bill and its potentially detrimental and far-reaching implications for religious freedom in South Africa if passed into law in its current form. In this video, we will look at the proposed amendments to the definitions of equality and unfair discrimination in terms of the existing Act, and also some practical examples of what this means for organizations and persons of faith. Turning first into the definition of equality. The existing Act defines equality as the full and equal enjoyment of rights and freedoms as contemplated in the Constitution, and it includes both de jure, that is legal, and de facto, that is in practice equality, and also equality in terms of outcomes. Now, what does the Amendment Bill do? It proposes a broadening of this definition to also include, amongst other things, equal rights and access to resources, opportunities, benefits, advantages. Now, while this may sound like a good thing, this proposed amendment in fact goes much further than the substantive equality or the equality of outcome that our Constitution has in mind. Practically, and in the context of religious freedom, it means that all persons will have an equal right to, for example, become a member of a church or other religious institution, to serve as a leader in the church, or to be employed by the church. And the fact that that person's own religious convictions and beliefs may go directly against the religious convictions and beliefs of the church or the religious institution would be completely irrelevant. Turning then to the definition of unfair discrimination. Again, the existing Act defines discrimination as any act or omission which either imposes burdens, obligations, or disadvantages on any person that it doesn't impose on another, or B, withholds benefits, opportunities, or advantages from any person that it doesn't withhold from another. And that could be on any of the prohibited grounds, including, for instance, race, sex, gender, sexual orientation, religion, and so forth. Again, what does the Amendment Bill do? Now, it proposes that this definition be broadened so that someone who simply feels prejudiced or that their dignity has been undermined on one of the prohibited grounds, even if that was not the actual reason for the discrimination, can now allege discrimination. So the effect of this is that the definition of discrimination becomes increasingly subjective. In other words, if the person who alleges discrimination says they feel prejudiced or their feelings have been hurt, that is enough to establish discrimination. And the fact that the person, the church, or the religious institution against whom the complaint is made had no intention whatsoever to discriminate against the person and did not treat them differently because of their sex, gender, sexual orientation, religion, or for whatever other reason they may allege, it makes absolutely no difference. In fact, the Amendment Bill specifically says that intention is irrelevant. Practical example. Let's say, for instance, an usher on door duty on a Sunday accidentally overlooks the couple who's standing in front of the queue to enter the building and helps the couple behind them to their seats first. Now, if the couple in front of the queue happen to be part of the LGBT community, they could allege they feel prejudiced or their human dignity was undermined because they were not first to be shown to their seats. They would then be able to lodge an unfair discrimination claim against both the usher and the church, even if their sexual orientation had absolutely nothing to do with it and there was no intention to discriminate. This is potentially very dangerous because it effectively removes any possible legal defense to an allegation of discrimination. And once discrimination has been established, the only way to escape liability is to show that even though discrimination took place, the discrimination was nonetheless for a fair reason. And it is also important to note, as various cases have already shown, a defense based on one's religious convictions and beliefs is not easy to prove, and it will be even more difficult if this amendment bill is passed into law. Clearly, this bill has radical implications for our religious rights in South Africa, and we must oppose it. And we therefore call upon every individual and every denomination, church, every faith organization to make your voices heard on this bill. And you can do that by making a submission before Friday, the 30th of June. A template submission is available on the 4SA website, which can be used as is or adapted and sent into the Department of Justice. For more videos like this that explain what the PEPUDA Amendment Bill is about and why it is such a major threat to religious freedom, visit our website at www.foresight.org.za or follow us on Facebook at Freedom of Religion SA. Thanks for watching. Please like and share this video far and wide so we can push back against this unnecessary and unconstitutional government overreach into our lives.